All right, I think we'll get started again. I think everybody's had a chance to check their emails, call their stockbroker, whatever else they needed to do. Maybe commodities broker over here. Our next speaker is Amy Arndt, and Amy is a partner with Lindquist and Venom over in Sioux Falls, and she's an Augustana graduate, and for her undergraduate degree, went to the University of Nebraska College of Law, graduated from there obviously, and she is currently the chairman of the Business Law Committee with the State Bar, and like Terry Pendergrass was instrumental over the last 4 years of developing and helping draft legislative changes to the limited liability statute. So we're very fortunate to have Amy Arndt here to speak on that topic. Thank you, Amy.
Thank you for inviting me to speak today. I'm going to break my presentation up into 3 separate parts. The first will be an overview, and it will be a little bit technical. I will go section by section of the LLC statutes, just because there are changes to particular statutes, and I think it's particular provisions, and I think it's important to point those out. I will also discuss the practical applications and implementation procedures. That will not take very long, as I will go into more depth later. We did not in South Dakota rewrite the entire LLC statutes. We did not adopt the entire Uniform Act. Rather, we took the best of those provisions that we thought would work well within South Dakota's LLC statutes and incorporated those within our current act. So I will go through the changes and the provisions that we did adopt. Then I want to cover just a couple of other topics that our Business Law Committee is covering this year as a committee. So if you have impact from a business practitioner's perspective, you know who to contact, and you can provide input on those particular statutes. And then the third thing that I want to go over today is there have been substantial changes in the private equity Rule 506 Reg D offerings, private placement securities transaction, private placement memorandums. Some of you may be familiar with those. It's a way that, and some of you work regularly with those, but there are significant changes in the regulatory landscape of those that I just want to cover very briefly so that you're aware of those items and that you know where to go to get additional information in the event your client asks for information on the same. So let's dig in. So the LLC process started when before Pat Metzinger was president of the bar. He was chair of the Business Law Committee. And we undertook to review and do this as a Business Law Committee when the Uniform Laws Commission or the regulatory landscape of other states in the United States deemed something very important, changes in the corporate statutes, changes in the partnership statutes, changes in the LLC statutes. It gets on our radar very quickly in South Dakota because, as Pat indicated, we are at the forefront of asset protection statutes, estate planning, as well as just business and transactional planning. And so when the Uniform Laws Commission in 2006 adopted what they call ROLCA, Revised Uniform LLC Act, it got on our radar very quickly. And we started reviewing it, and the way we do it in our committee is we over-analyze every single provision in chart format and take the new provision, compare it to what's in our current statute, and have subcommittees analyze whether or not it should be adopted or fit into our South Dakota statutes. So we began that process about 4 years ago. We have 3 or 4 subcommittees that are designated, and it took us a long time to go through that process. Dean Gooey, or Professor Gooey at the time, now Dean Gooey, is very active in that process. He is very active in the uniform laws. So the changes that have transpired have been very thoughtful, and there's a lot that goes behind each one. I'm here to present on behalf of all of those subcommittees. I was involved in all the discussions, but not necessarily all the analysis. So if I don't know the answer, I'll get the answer for you, or I put our subcommittee names of people who are on the different subcommittees in my materials as well. So if you have a particular item. that you want to follow up on, you can follow up with me or somebody on the subcommittee. 9 states have adopted ROLCA in its entirety, and 1 additional state will do it, or is seeking approval from the legislature this year. There's approximately 20 states that have done what we have done, in that, what South Dakota has done, in that we went through and not cherry picked, but decided what provisions in ROLCA we wanted to incorporate within the LLC statutes. So an overview of the changes that were incorporated into our South Dakota laws are, there were certain definitional changes. Certain changes were included on record and signature and electronic communication. There was a reorganization of the disassociation, merger, and conversion statutes, so those all are incorporated now within 1 article, Article 9. Clarification on acts that constitute transacting business within the state, and then some additional drafting on derivative actions. So let's start. I'm going almost word for word or directly through the outline. Article 1, Section 101. Contribution is a new provision that was added into the statutes. This is any benefit that is provided by a person to the LLC. So it includes assignment of promissory notes, compensation. It also includes services, service agreements, service contracts, promises to pay in the future. And so there's clear definition on what can and can't be included as a contribution to an LLC. Foreign limited liability companies, this provision was changed in that our current statute, or our old statute, I guess I should say, our old statute said that it could be a foreign limited liability company or any entity that was deemed by that jurisdiction to be somewhat similar to South Dakota's. We've removed that level of unclarity, and now it says it must be deemed by that jurisdiction to be an LLC. And that was more just because LLCs were not always a common entity, and now they are. The definition of limited liability company was just modified to include foreign limited liabilities within the definition of itself. Member definition is new in that an organizational person, a person who forms an LLC is called the organizer of an LLC. And members of the LLC are not necessarily, but can be the same as the organizational member. Members can be identified prior to organization of an entity, and that is made clear by the new definitions of member within Article 1. Operating agreement, the significant change in here, and this is a practice pointer for everybody, in that single member LLCs used to be referred to, or the governance documentation that used to be drafted with regard to single member LLCs was referred to as a declaration. That is no longer the case. So you no longer need to have an operating agreement that is for multi-member LLCs and a declaration that's for single member LLC. It's now just called an operating agreement. And you don't need to go back and amend if you have declarations for single member LLCs, but it makes it clear that there is not that distinction going forward. The definition of signature was revised to allow for electronic signatures. Many people have added that into their practice documents, as a matter of practice anyway, but now it allows, it specifically references electronic signatures. And it incorporates the definitional term of intention to authenticate the document. So if there's a clear intention to authenticate the document that is being signed, that's the underlying governing standard. And then there's a new definition for transferee. A transferee is all or part, or the recipient of all or part of a distributional interest, regardless if they are not a member. Section 103 was also revised pertaining to the operating agreement. There was a clarification of what items may or may not be waived within an operating agreement. This is probably one of the items that had the most discussion at the uniform laws level, was this manifestly unreasonable standard. And so if you have an interest in learning more about what items can and can't be waived within an operating agreement. This is something that you should study up more on. The manifestly unreasonable standard provides that certain provisions of an operating agreement may be included or excluded so long as they are not manifestly unreasonable. And this is a carryover from the revisions that we did to the Uniform Partnership Statutes about 7 years ago. And it's a carryover from those provisions, and it makes the provisions of what can and can't be included within your governance documents uniform among those acts. The new standard in which under an operating agreement you can define or limit good faith and fair dealing and the duty of loyalty. Again, you can specifically exclude out certain acts of members from being violating, or not from being violating, from violating the duty of loyalty to other members within the organization. So there is a lot of, I call it bifurcation, that's not necessarily the right word, but a bifurcation of interests of a member being able to do certain things. The best example is real estate partnerships, or easiest example, real estate LLCs. I have a guy who does real estate LLCs, but he has 8 of them. It doesn't violate his duty of loyalty to be involved in other real estate transactions with other individuals, as long as it's specifically stated. Within an LLC agreement, let's say I'm doing a manufacturing company, that may be a situation where you wouldn't have one guy that does manufacturing on several different entities. He has the duty of loyalty to only operate with regard to that particular interest, unless it's specifically stated otherwise within the agreement. So from a practitioner standpoint, you need to dig into what is the intent of your members on that particular LLC. And you want to make sure you're not representing the members, but you want to make sure that all of your members' understanding of what their actions and what their duties are with regard to that LLC are very clear. If they intend to also compete on a different level with other real estate developments throughout town, then you need to state that. And so long as it's stated clearly, then it is deemed to not violate the duty of loyalty. So this is something that you should look very closely at when you're forming your governance documents. A lot of people have their blank forms that they go through. It's important to go through and ask yourself, what is the intention of each member? And do I need to specifically exclude activities that I know he or she is going to do in business otherwise so that they don't violate these provisions? Section 112 is the next section that has been revised. The effectiveness of filings. If a record is filed with the Secretary of State's office that otherwise conflicts with the operating agreement or any other governance document that wouldn't be filed with the Secretary of State's office, the document that controls among the members are the governance documents. The document that controls with regard to third parties is what would a third party know? A third party wouldn't necessarily know what your governance document says because you don't file that with the Secretary of State's office. So the document that controls with regard to third parties is the document that's actually filed with the Secretary of State's office. That's more technical in nature, but it's important. Kind of goes back to Register of Deeds filings or UCC filings. What is reasonable that a third party would know, and they would not necessarily know what your internal governance documents say. So the Uniform Roll Call just made that clear, and we added in Section 12, which is a new section in the LLC statutes. Section 113 and Section 114 are also new sections. Exhibit C to my materials, I guess I should back up, is a red line of what was actually incorporated or revised in the LLC statutes. And that is as provided by the Legislative Research Council here in South Dakota. So we've redlined everything, and that's in Exhibit C. So if you have any questions, refer to that. Article 2, there was no revisions to Article 2, but I want to point out a term that you may hear from clients or requests that you may get from clients is a term called shelf LLCs. Some clients may come in and say, hey, tell me about this. We did not adopt those provisions in South Dakota. In 2006, when these were when ROLCA adopted their uniform law, in 2006, there was the perception that it saved time to be able to form an LLC in advance of actually doing the business activity, or in advance of using that entity to purchase or acquire assets to put into that LLC. There were certain circumstances where there had to be an existing or ongoing LLC that had been in business for a year or two in order to bid on certain types of contracts. Certain types of business ventures had to show corporate longevity within certain states. And then in Wyoming in particular, you see a lot of shelf LLCs. Then certain businesses were packaging these empty LLCs together and selling them for purposes of bidding on contracts or for purposes of otherwise acquiring business interests. Well, the main reason back in 2006 was it took a long time to form LLCs in some states and in some jurisdictions. And so there was a concern that you would get to the end of the race in an M&A transaction or any other type of transaction, and then the entity itself wouldn't be ready or would otherwise be disqualified from getting financing or getting the regulatory and license approvals. That reason has dissipated in some respects. It's now easier to get formed. It doesn't take as long to get formed in many states. Many states have online filing. Many states allow electronic filing. States such as ours, you can do the $50 expedited filing fee and get filed usually within the next 24 to 48 hours. So the reason that it took months to get filed isn't necessarily, there anymore. And in addition, since 2006, there's been a lot of skepticism on exactly what shelf LLCs are, and I think a lot of people see through it and see what people were trying to do with them over the years. So in any event, after review by our committee, we just decided to leave it alone and not adopt shelf LLCs within the state of South Dakota. So there were no revisions with regard to Article 2, and I just point that out. If clients ask you if we have shelf LLCs, the answer is no. Article 3, again, there were no revisions to relations among members and managers to persons dealing with LLCs. The same agency provisions continue. Outward manifestations is important, and the reasonableness standard is still in play. Article 4 is the relations of members to each other and to the LLC. Section 401 is revised with some additional provisions in there. There was a change to the contribution definition that I referred to in Article 1. And Section 401.1 is new, and it clarifies the type of properties that can be contributed to an LLC. I think maybe because there is concern on whether or not in South Dakota what types of property may be contributed to a corporation, that there is some confusion over what types of property can be contributed to an LLC. So Section 401.1 makes that clarification. Section 402 was revised. I won't go into detail on that. Section 403, there was revision or clarification to the ability of an LLC to get insurance coverage for its members and managers. There had been some case law on whether or not a limited liability company could obtain E&O insurance coverage for its managers or members on items that were not otherwise waivable under a governance document. So could I get insured coverage for a manager if they did something that would otherwise not be allowed to be excluded under the manifestly unreasonable standards in the governance documents? And this provision makes it clear that you can get coverage for any reason whatsoever on any of your members or any of your managers. And we, in practical application, we get that question a lot. So-and-so doesn't want to serve on my board because they're worried about the potential liability limit or liability concerns they have on reviewing financials or otherwise acting in the LLC's interests. And so this makes it a little bit easier to say that we can insure you for any reason. Now, there may be other business reasons they don't want to, but you can. And this section makes that clear. Section 406 also was revised. This is governs the distributions that are made by an LLC. And a new section was added to make clear that there are no clawbacks for distributions that are made for reasonable compensation, and also for contributions and payments to retirement plans and other benefit plans. I think there was some case law activity with regard to whether or not limited liabilities were able to pay out certain payment of compensation or benefits, and whether or not that would be subject to the clawback rules. And this makes it clear that there will be no clawback. So long as the compensation was reasonable, you can't deem huge bonuses at the end of the year, and that may be subject to a clawback, but so long as it's reasonable compensation, that's considered okay. Section 407, the liability for improper distribution section remains the same. The only change is that you can make in your governance documents, you can make it clear that certain individuals, whether it's a member-managed LLC or a manager-managed LLC, may not have the authority to authorize a distribution. And in the event that it's clear within the governance document itself that they do not have or did not have the authority to make the decision on whether or not there was a distribution, they cannot be liable then, because this section's huge because it imposes personal liability on members and managers for making improper distributions. And there is the ability, so I point this out because if I have a manager or in a member-managed LLC where the designation of who's going to make contributions out of an LLC is, I have another individual that's going to take that role on or that task on, I'm going to put it in my document because I don't want the person who's not making that decision to be liable. So make sure that's clearly stated within your governance documents. Section 409 is the next section, and this is the general standards of members and manager conduct. The only real change here was that there's a clarification that a member's duty of loyalty and duty of care to an LLC does not prevent that member from bringing a derivative action in the event that they deem that necessary. Article 5. Pat talked a little bit about charging order statutes. The only revision that was made to this section was with regard to that a notice requirement had to be sent to the LLC prior to the company, prior to a charging order being effective, so that the company can be involved in the process. Prior to this time, this process could have started with a charging order statute directly against a member, where the LLC had no knowledge and could not otherwise be involved in the process. So this is important from an LLC perspective, to just allow the LLC and the company to be active in the process. And so before the charging order can be issued, notice has to be given to the LLC. Article 6 is member disassociation. I don't think there were minor modifications made to this, and a corporation or other entity, it was clarified that the words corporation or other entities were not included in the statute prior. Article 7, there is a reserved section of the statute. Article 8, winding up of the company's business, that is unchanged. Article 9, this is what I alluded to earlier, or at the beginning of my presentation. Merger, conversion, and domestication now are combined into one section, Article 9. This makes a uniform process for all of these types of actions, whether you're converting, merging, or domesticating a foreign LLC. These are all now housed in Article 9. The relevant provisions are that prior to, let me back up, almost the entirety of the ROLCA statutes, the Revised Uniform Limited Liability Company Act statute pertaining to mergers, conversions, and domestications, was adopted by the state of South Dakota. So the provisions have changed, but they are not very different from our provisions before. The statutes just are worded a little bit differently to use the definitional changes that were revised in the article or in section 101. and it's a different statutory framework because it's all included within Article 9. So it's going to look a little different to the practitioner, but the practical reality of the forms that you draft and the implementation are not different, with the exception of a couple of things. Prior to the adoption of the ROLCA statutes on merger, conversion, and domestication, only a partnership or a limited partnership could be converted into an LLC. After the adoption, it applies to all types of entities: LLCs, general partnerships, corporations, business trusts, LLPs, LLLPs. They can all now be merged or converted into a statutory LLC. And so this is a change from our prior statutes. Also with regard to merger limitations, before LLPs, LLPs, LLLPs, and business trusts were excluded from merger, and now they are allowable under the new ROLCA statutes. And those are the main things I wanted to point out.